Caribbean, joined by water, connected by culture, and linked by a common heritage.
But since independence, divided by politics and ideology, after more than 50 years of independence and some of the best education, Caribbean countries are at the risk of becoming failed states, surviving only on grants and assistance from external agencies. The question needs to be asked: why has this region found itself in this predicament? It's time to shatter the artificial barriers and unite the region for social and economic development. It's time for Caribbean people to move from complacency to action. It's time to take control of your future. It's time that you realize that you are the agent of change. Let's discuss the issues on Time to Face the Facts, starting right now.
Hello everyone, and welcome to this edition of Time to Face the Facts, the program where we get beyond the fluff and deal with the real issues. The issue we are dealing with this evening is justice in the Eastern Caribbean. 50 years of the Eastern Caribbean Supreme Court. Of course, not Jerry George. I'm Beverly Sinclair, sitting in for Jerry George. And with me this evening to look at the ECSC, we have in studio Ruggles Ferguson, very well known and very prominent attorney in the Eastern Caribbean. He has served in many areas. And Ruggles, you want to tell us a little bit about yourself?
Well, good evening, Beverly, and good evening, listeners. Well, I'm the former president of the Grenada Bar Association and the immediate past president of the OECS Bar Association. I sit on the executive of the OECS Bar Association as the immediate past president.
Okay, and joining us virtually from Antigua, we have eminent QC, Miss Anne Henry. Anne, welcome to Time to Face the Facts. Do you want to tell the viewers a little bit about yourself?
Yes, well, thank you very much for having me, Beverly. I'm very happy to be participating in this very important discussion. I have been involved in a number of regional activities connected with the Bar Association, of which I'm a member, the Antigua and Barbuda Bar Association. And I have been on the OECS Bar Association as the vice president some years ago. More recently, I chaired and was a member of the Council of Legal Education, which is responsible for education of attorneys at law in our region, and which operates 3 law schools. As many of your listeners may be aware, we have law schools in Trinidad, Jamaica, and in the Bahamas. So I was associated with that. But I have been a practitioner in Antigua for many years and have been involved in the work of the court as well, on both sides, as an acting judge as well as an attorney at law practicing.
And our other guest who is joining us virtually as well from St. Vincent and the Grenadines, we have Miss Renee Batiste. Renee, can you tell the viewers a little bit about yourself, please?
Good evening. I've been a member of the bar in St. Vincent and the Grenadines for about 4 years. And I've had the honor of working in the offshore sector here from 1986 to my private practice from 86 to the 2001, when I took time off to be involved in politics and was elected to Parliament and was a parliamentarian and a senior member of the cabinet of the government of St. Vincent from 2001 to 2010, when I retired, and went back to my law practice in 2011. And then in 2014, I was elected as president of the Bar Association of St. Vincent and the Grenadines. I've always been, even though I was an MP and not practicing at the bar, I would continue to have some interest in what's happening with the Bar Association, and now we are at the end of our term, actually, to have elections next week.
Okay.
And I'm president now of the Bar Association, and I've I've also participated in activities of the OECS Bar from its inauguration and continuing up to now, except when I was in Parliament.
Thank you so much. We are going to take a very short break, and we will be back with our quite eminent guests to look at 50 years of the ECSC. What kind of justice have we had over that period? Stay with us. Welcome back, viewers everywhere. We are going to jump right into our discussion this evening. We start with Ruggles, 50 years of the Eastern Caribbean Court, the Supreme Court. Over this 50 years, what is there to celebrate? Tell us what should we be celebrating in this 50th anniversary?
Yes, well, thank you, Beverly. 50 years for any institution is indeed a landmark, and the Eastern Caribbean Supreme Court is no exception. First and foremost, the Eastern Caribbean Supreme Court is unique, not just in the region, but in the entire world, based on its structure. That court serves 9 islands in the region, 6 independent states: Antigua, the Federation of St. Kitts and Nevis, Commonwealth of Dominica, St. Vincent, St. Lucia, and Grenada, and 3 what is known as overseas territories, the BVI, the Montserrat, and Anguilla. So a total of 9 states. We have 1 Chief Justice, 1 Judicial and Legal Services Commission that is responsible for the appointment of all judicial officers, including our judges and magistrates throughout the region. And we have 1 Court of Appeal that serves the region, the entire 9 states. It's an itinerant court, meaning that it moves from island to island. Very challenging indeed. And serves most of these islands every quarter. They come to Grenada. So in that sense, it is very unique. You would not find any other court in the entire Commonwealth and probably the world that operates in the way that the Eastern Caribbean Supreme Court operates. If you are to use the contrast of Trinidad, 1 Chief Justice, 1 Judicial and Legal Services Commission that serves Trinidad and Tobago. Barbados, 1 Judicial and Legal Services Commission for Barbados, similarly for Jamaica, for Guyana, and these countries. And therefore, by its very nature, it creates an even greater challenge for the operations of the court when you serve this broad-based.
So you're saying the uniqueness of the court is something to celebrate?
Well, it has survived and grown from strength to strength over these past 50 years. In fact, the theme for this year's celebration, celebrating the past, embracing the future, the focus, of course, of any court, of any justice system, you test it by access to justice. In other words, are these courts accessible to our people? And if we understand the structure of the court, first of all, at the magisterial level, you have the magistrates' courts, and we have magistrates' courts in every single parish. For example, in Grenada
I don't want to talk
rest
too
of
much
the
about the
region.
magistrates now, because we're going to come back to it.
Okay.
I'd love to hear from Renee and Anne. You talk about the uniqueness of the court. Renee, in your mind and from your experiences, what should the ECSC and the people of the Eastern Caribbean be celebrating in this 50th anniversary?
I I think we should celebrate the fact that we have grown in our jurisprudence, we have grown in the management of the court and the expansion of the court, in that they are serviced by jurists from the very Caribbean itself. And from our own state, we can identify judges who have been appointed to the court. And I think we may be unique. Ruggles I'm subject to correction here, but I think we're unique in having so many women serving as justices of appeal in the Eastern Caribbean Supreme Court, and having a lady, a dame, as the head of the court.
For the first time, though. It's the first time. It's the first time we're having
able to have from our own within the Caribbean. It wasn't imported, neither was it imposed. But these are people who are from the Caribbean, who have worked within the Caribbean and understand the nature of our history, our culture, our political foundations, understand the society, because you are going to judge the people of the region and understand the roots of several of the growth in the law and the law reforms within the region. And the court itself has undertaken several reforms, especially over the last 5 years or so.
Okay. Well, I was adding on to your point that this is the current Chief Justice is the first time we've had a woman sitting in that position, right, Ruggles?
Indeed.
Right. So
appointed in 2012.
So that is something to celebrate as well.
Well, certainly, the profession.
And I think Ruggles would agree with me, and I'm sure my learned senior would also agree, in the reforms that are taking place in setting up the commercial division, the family division, and now we are doing the probate regulations. I know they have been circulated, so the reform work is continuing, and setting up also as well the Judicial Education Institute. So I think Senior Counsel will be able to give much more information in this debate tonight.
Yes, and we will go straight to Senior Counsel QC. Anne, what are we celebrating? We've heard about all the different achievements having a woman heading the court. We've heard about the uniqueness. What do you think we should be celebrating, Anne?
Okay, well, I certainly want to endorse the celebration of Dame Janice, the first woman to have been appointed to sit as the Chief Justice of our court. And I think our court has shown the maturity and the ability to rise to meet the challenges of a new era in putting a woman at the helm. That is one. But I listened at the very beginning of the program, and I noted that one of the objectives is to unite the region. I heard the speaker at the very start of the program speaking about it. It's time to unite the region. And I think that is one of the reasons why we celebrate our court. Our court is a resilient court. It has lasted 50 years, which when you consider the youth of our region, we are all very young nations, to have a court that has served the Eastern Caribbean in the way that the court has done over the years, for 50 years, is itself a point of celebration. That is one. Second thing that I think that we need to recognize and celebrate is that the court has shown the capacity to change over the years to meet the needs of the region. The region has gone through a lot. We have seen, for example, the political changes that took place in Grenada, when I'm now talking about the 70s into the 1980s, where the court originally started out as being headquartered in Grenada, and during that period it was shifted to St. Lucia, which is where it now is headquartered and has continued to be headquartered. The court has changed because it has now sought to unite the region that we are speaking about, through the integration and connectivity of IT. For instance, on the last sitting of the Court of Appeal in Antigua, I was in the courtroom and a matter was being argued. The lawyer who was on one side of the matter was in Nevis, sitting in his office, and the application was heard by the court with one lawyer in Antigua, one lawyer in Nevis. To my mind, that demonstrates the access to justice point that Rose raised a few minutes ago, in that the cost of prosecuting that application was substantially reduced for the litigant in Nevis, whose lawyer didn't have to travel to Antigua, or other arrangements did not have to be made in order for that application to be dealt with.
Yes, and
the other thing that I think that we... Sorry.
Go ahead, Anne.
Yeah, I was also saying that in terms of the capacity to meet the needs of the region and the changing requirements of our world in which we live, the court has sought to introduce alternative dispute resolution through mediation. So it is not like when I started to practice, you filed a case in court, and eventually many years later, you got your day in court to stand before the judge, and the judge would make a determination of the matter. So many years later, many dollars later, you would then have your matter adjudicated. With the alternative dispute resolution through mediation and through case management, the court is constantly assessing the viability of the case and the issues before the court in such a manner as to save costs and so that a matter can now be resolved whether through mediation or through case management in a much speedier fashion than would have been the case in the past. So those are the things that I think we have observed over the last 50 years, the changes. Some of them, and I've only just touched on them very briefly,
right.
Some of them which to my mind give us a great deal of occasion for celebration.
And I am glad, Anne,
improve as the years have gone by.
Anne, I'm glad you mentioned the costs associated with hearing these various different cases in these various different jurisdictions, because I would be interested to know, how do we manage to find money to take care of the expenses of a court which is set up in this manner? And maybe Ruggles can help us here with this one.
The expense, that probably is one of the greatest challenges facing the court. As Anne indicated, the court is headquartered in St. Lucia. That's the nerve center of operations of the Eastern Caribbean Supreme Court. And the court depends on resources.
Do you know how many people the court employs on a full-time basis?
No, well, certainly, I don't know the figures for St. Lucia, the headquarters, but you have the registries, Supreme Court registries in all 9 jurisdictions. So the responsibility would be on the respective governments to pay the staff at these registries. The court, for example, just to illustrate the growth of the court over the last 50 years, we have started off with about 5 judges and moved. Right now we have throughout the Eastern Caribbean, we have well over 20 judges, and then we have 5 masters, and those are the masters deal with the case management, the caseload, managing the cases, and they move from island to island. So we have about 5 masters, and you have 3 different divisions of the court. So financing of the court would always present its own challenges. You depend on the contributions from the various governments throughout the region. And we all know the budgetary constraints that exist. But notwithstanding that, the court has been able to grow significantly. For example, there is the commercial division of the court in St. Lucia. In St. Lucia, also in the BVI, there is a court that deals exclusively with commercial matters, and you know the nature of commercial matters.
Why do we need a commercial court at this level when we have the CCJ?
Well, we're not part. Remember, the CCJ operates from 2 jurisdictions. One, the original jurisdiction that interprets and applies the revised Treaty of Chaguaramas, and the appellate jurisdiction, where it serves as a final court of appeal.
Yeah, but we're not looking at the appellate jurisdiction, no, just the original jurisdiction.
But the commercial jurisdiction is operates is a judge at the High Court. And if, for example, one is dissatisfied, then it goes through the normal process, just like criminal matters, regular civil matters. It goes to the Court of Appeal, and then it goes to as far as the Privy Council, it can go. So I'm saying that the CCJ cannot replace that mechanism because it's a court that operates.
So if someone has a commercial matter in which they are aggrieved, they can't go to the CCJ with it directly?
Well, it depends on the nature of the commercial matter. If it falls within the confines of the revised Treaty of Chaguaramas, it involves an issue between states, for example, under CSME, then you can go to the original jurisdiction of the court. But regular commercial matters, you would have to start in your own jurisdiction, which is the High Court. Remember, the court exists at basically 3 different levels, well, 4 different levels: the Magistrates Court on the one hand, and then you have the High Court. These are the original courts that you go to. Then after that, you have the appellate jurisdiction. If you are dissatisfied with the decision of the magistrate or the judge, then you go to the Court of Appeal. And if dissatisfied with the decision of the Court of Appeal, then you go to the highest court, which for most of us, save for Dominica, now is the Judicial Committee of the Privy Council in London. So these commercial courts, really for these courts, you have specialist judges who are trained in commercial matters. And as Renee indicated earlier, the court also has a criminal division now. You have a civil division of the court. The family division is being developed of the court. So now the court, as apart from branching off 50 years ago where a judge heard all matters, while you still have some of that, but the court is developing specialist divisions of the court to create more efficiency in the hearing of the matters.
So what you're saying then in relation to commercial matters is that certain types of matters can go directly to the CCJ, but some can't.
Yes, well, when we deal with that, some kinds of matters that fall under the revised Treaty of Chaguaramas that touch on concern, for example, CSME, free movement of people, free movement of goods, free movement of capital, all of these issues, they are the CCJ in its original jurisdiction has exclusive jurisdiction for the hearing and determining of these matters. So, for example, if you have a matter that enters the High Court in Grenada, for example, and the judge determines in hearing that matter that it touch and concerns the interpretation of the revised Treaty of Chaguaramas, then that judge would not have jurisdiction to finally determine that matter. That has to be referred to the CCJ, or you can go straight to the CCJ. However, in BVI, for many of these commercial matters, instead of going to the regular courts, you would file an action in the commercial court. When the family division is set up and running, instead of like the same judge who hears criminal matters hearing family matters, you have specialist judges trained in family, and they, like exist in Trinidad and Tobago, would hear all matters touching and concerning family, whether it's divorce, custody, maintenance, and so on.
And how long ago do you say that commercial division was set up?
The commercial division was set up in BVI several years ago. I can't remember the date.
Renee had mentioned it.
Between 5 to 8 years ago, the commercial court was set up. It was set up in BVI. And I think, though, that the question that you have raised in relation to cost and the cost of establishing the court and the costs of running the court is a very important one on 2 levels. One of them being that, and the information that you had requested a little earlier, the staff, the support staff in the central, in the headquarters, has grown from a total of 6 in the year 2000 to approximately 20 now. So that the court staff, the judicial officers, and the support staff around the headquarters particularly, but in other parts of the region, has grown exponentially. The cost of running the court is supposed to be the responsibility of the participating governments. And I think it is an open secret that that is one of the greatest challenges that the court presently faces, because in the setting of priorities, governments do not always perceive courts as being very high on their list, on their pecking order. So that is one of the significant challenges. And in point of fact, there have been many persons who have called for the establishment of a trust fund, similar to the one that funds the Caribbean Court of Justice, to fund the Eastern Caribbean Supreme Court and the different divisions, including the commercial division. And I think that the commercial division becomes very important when one considers the extent of international business that is conducted within the region, particularly in the BVI and in Anguilla, where international business corporations are the order of the day. I believe other jurisdictions also have IBCs, but none to the extent that those two jurisdictions do.
All right, and hold that thought. We have to take a break, and we will pick up when we get back. Stay with us right here on Time to Face the Facts as we look at 50 years of the Eastern Caribbean Supreme Court.